A federal judge continues to turn the screws into Donald Trump and slow down, if not block, that $10 billion lawsuit he filed against the taxpayers, against the United States government, alleging that in 2019 there was a data breach. By the way, when he was in office, then the data breach in the IRS by this guy named Little John that resulted in 7,500 high net worth people's taxes being leaked or exposed, and that Donald Trump's one of the people who was targeted.
So MeidasTouch just exposed Trump's most brazen corruption scheme yet, a fake $10 billion lawsuit against his own government to steal taxpayer money. A federal judge is now calling out this scam for what it is. Let's break down how Trump tried to rob America in broad daylight.
So Trump, this past January 2026, in his individual capacity, filed a $10 billion lawsuit against the Treasury Department and the IRS, alleging that this caused him grievous injury and emotional distress. And
the timing here is everything. Trump waited 7 years after the 2019 leak to file this lawsuit, conveniently right after taking office when he controls both sides. He's literally claiming $10 billion in emotional distress while simultaneously being the defendant through his Treasury appointees.
Then he tried to pull off a settlement with himself and then went on various media networks and bragged about how, I guess I've already won the case. I'm doing a settlement with myself.
Think about this. It's like robbing a bank you own and then congratulating yourself on TV for the successful heist. Trump openly admitted he's settling with himself, which should trigger every fraud alarm in the federal court system.
Then in the federal court where he filed the lawsuit, he informed the judge, we need 90 additional days to enter into a settlement. So the defendant is agreeing that they don't even want to respond to the lawsuit. They don't want to file a motion to dismiss or actually fight the lawsuit. The defendant actually just needs 90 days to reach a settlement so we can figure this out. And you want to know who the defendant is? Oh, hi, I'm the defendant. It's me, Donald Trump, and I'm settling with you, Donald Trump. Oh.
This is corruption in plain sight. Trump controls Treasury Secretary Bessent, the IRS commissioner, and has executive orders giving him final approval over their decisions. He's both plaintiff and defendant in a fake lawsuit designed to transfer billions from taxpayers to himself.
So that's the dynamic that was at play. And the judge said, wait a minute, are you saying that you're doing a lawsuit where you're the plaintiff and now you're saying you're also the defendant because you're ordering Treasury Secretary Scott Bessent and the IRS acting commissioner to reach settlements with you? And there's already numerous executive orders that say you have final sign off on all final decisions, and these entities aren't independent at all in the first place. So you're doing settlements with yourself right now?
The judge nailed it perfectly. Federal courts require real adversarial proceedings, actual opponents fighting genuine disputes. When both sides work for the same person and want the same outcome, there's no legitimate case, just an elaborate theft scheme disguised as litigation.
And then the judge said, whoa, I'm not going to give you this 90-day extension of time. I'm not going to require that you file like a motion to dismiss yet for the defendants. I need to understand if this is even a case I have jurisdiction over.
Article 3 of the Constitution requires cases and controversies, meaning real disputes between actual opponents. Trump's fake lawsuit fails this basic test because he's essentially suing himself. The judge is absolutely right to question her jurisdiction over this sham.
So as we previously reported on the MeidasTouch network, the federal judge did something called sua sponte. On her own initiative, the federal judge said, I need briefing from both parties, not simply the plaintiff, Donald Trump, or the defendant, basically Donald Trump, who wants to give our taxpayer dollars to Donald Trump. We need to hear from both of you separately about the issue of, is there adverseness? Are you against each other? Is this a plaintiff versus defendant, or is it you just doing a case where you want me, the judge, to rubber stamp basically a collusive arrangement? I'm not comfortable doing that.
Sua sponte means the judge acted on her own initiative without anyone asking. This is huge. It shows she recognizes potential fraud and won't rubber stamp corruption just because Trump expects it. She's doing exactly what judicial independence requires.
Then the judge just did something else that's very, very important, that's not getting enough attention. The judge, her name is Kathleen Williams, she appointed 3 law firms as friends of the court, amicus curiae, to advise her on Donald Trump's suit versus the IRS. She earlier suggested, as I noted, and Josh Gerstein points out over here, that the parties aren't adverse enough to proceed. And so she said, I'm worried about the issue of adverseness and collusion here. I'm not going to rubber stamp giving $10 billion of taxpayer dollars from one side to the other when it's the same side. So I need to understand my role. So
appointing 3 separate amicus curiae firms is extraordinary. Judge Williams knows Trump will attack any decision blocking his money grab. So she's building an ironclad record with multiple independent legal experts advising her. This shows how seriously problematic she considers this case.
Not just one firm, she did 3 amicus curiae to provide instruction to her. Why not 1? Why not 2? Why 3? Because she wants it to be reflective of a broad cross-section of, that's how big it is. $10 billion is a lot of money, and she wants fearless lawyers who can provide independent guidance.
3 firms instead of 1 signals the judge expects Trump to appeal and attack her decision viciously. She's preparing bulletproof legal reasoning with diverse expert input. $10 billion would be the largest presidential self-dealing scheme in American history.
My prediction is that the judge, the easiest course of action is just I think it should be dismissed. I think the case should be dismissed totally. I think there's no jurisdiction, there's no adverseness. But I think the kind of middle ground compromise position is you stay the case, you toll the statute of limitations for another 2.5 years until Donald Trump's no longer president. And then you kind of kick the can down the road where there hopefully is an independent DOJ. I guess the worry is that if Donald Trump doesn't leave and does an authoritarian takeover, or somehow JD Vance or someone else, which I don't think is going to happen, what would that lead to? But at least you don't have the issue of Trump on both sides of this case, taking $10 billion of taxpayer dollars. I think the case should be dismissed, but I can envision the judge saying, so the statute of limitations doesn't expire. I'm going to stay this thing and press pause until the end of this term. Then we can redo it. And what's the rush? You didn't file this case. There's probably a statute of limitations issue anyway. Trump filed in January 2026. The incident happened in 2019. But you've waited all these years in general. So what's another 2 years going to do anyway? We have all the evidence. What would be the prejudice of waiting 2 years? This case should absolutely be dismissed. It's frivolous. Let me be clear about my view. It's heinous that it's even brought. But that may be just the solution that the judge chooses.
This analysis is spot on. Dismissal is correct because this isn't legitimate litigation. It's theft disguised as a lawsuit. If the case gets stayed until 2029, at least it prevents the immediate robbery and requires actual adversarial proceedings later.
It's unthinkable that another president would sue the government while in office for $10 billion, but Trump's a low-life scumbag, and this is what he does. So what do you make of it all, Harry?
No president in 248 years has sued their own government for personal enrichment while in office. Washington refused payment. Lincoln lived modestly during the Civil War. FDR took no salary increases during the Depression. Trump's corruption is historically unprecedented.
On the one hand, it's an issue of first impression. On the other hand, it's over 200 years old. The first thing I want to note is we're talking about the Constitution and the term in the Constitution that limits the federal court's authority to so-called cases or controversies. That's the very provision that I think Midas Mighty and Fed heads will be familiar with when there's a standing issue. And when a court finds that a plaintiff doesn't have standing, the court says no case or controversy, dismiss, bye-bye. It's a similar bedrock principle that what's happening is just what's happening here, two people that are really on the same side. I call it jumping the V. If it's a collusive lawsuit, it's not just a good idea not to bring it. It is literally unconstitutional.
The cases and controversies requirement from Article 3 is fundamental. It's why courts dismiss lawsuits lacking standing. Trump's scheme violates this bedrock principle because there's no real dispute, just collusion between parties he controls to steal public money.
So she's noticing. They thought, oh, maybe we'll sort of push this down the line, enter, I'm sorry, Mr. President, $10 billion, would you take 8 or whatever? But she can't even grant Ben this consent for motion where, of course, they both agree. They always both agree on everything. If she doesn't have jurisdiction, a court lacks power to act.
Exactly right. Trump expected to negotiate with himself. Maybe settle for $8 billion instead of $10 billion and call it a win. But constitutional limits on judicial power mean courts can't approve fake settlements when they lack jurisdiction over sham cases.
And notice, it's the same damn thing that they did with Mike Flynn. They're talking about perhaps doing it with all the January 6th defendants, these complete fictions of cases where instead of people opposing each other, they're on the same side. And how'd they pull it off with Flynn? They pulled it off by, we'll just go settle and just present that as a fait accompli to the court. But
this connects to Trump's broader pattern of judicial abuse. The Flynn case dismissal, planned January 6th pardons, and now this fake lawsuit all follow the same playbook. Use controlled government lawyers to manufacture favorable legal outcomes through collusive proceedings.
There's a special rule of federal procedure that says if the court didn't have jurisdiction in the first place, you can re-examine. And just as you say, and as the judge did here, the court can even do it on its own motion. So I think, and you're totally right, we have these powerhouse, John Gleeson, Faith Gay, Don Verrilli, and they're going to make a case. It's really a tricky position for the department, right? Because as you say, there's the law that says I, Donald Trump, lead and you do whatever the hell I say. There's another law out there that used to say you follow the interests of the taxpayers, but of course they ignore that.
These are legal heavyweights. John Gleeson prosecuted major mob cases. Faith Gay argued Supreme Court cases. Don Verrilli was Obama's Solicitor General. Their involvement shows how seriously the legal establishment views Trump's corruption attempt.
You can prove something is collusive by the facts. The most important case in the Supreme Court was when a dirty landlord was going to be sued. Instead, he paid off one of his tenants to bring the suit, but then he controlled it. And so you had to know the facts. And the court said, case is void from the beginning. So first, she's going to get really strong argument here from the likes of Verrilli and Gleeson. Second, you can't have Todd Blanche and company come in and make some bullshit argument about, we really will be adverse. This time we'll play it right because the law is so strong, the facts are so strong, and they're in a real pickle.
Perfect analogy. Todd Blanche can't credibly argue his DOJ will oppose Trump when everyone knows they follow his direct orders. The landlord case precedent shows courts will void collusive lawsuits regardless of how they're packaged.
And at a minimum, the department is really in a very tight spot, and we should all really closely follow what they're going to try to say, because how can they really deny that, of course, they do what Donald Trump says? The regs say it that have been passed under him, and the facts say it, and they're in a pickle.
Trump's own executive orders prove the DOJ follows his direction on all major decisions. They literally cannot argue they'll oppose him with a straight face. Their regulatory framework contradicts any claim of independence from presidential control.
You and I are going to do another take on this that people will be watching this weekend. But, Donald Trump injects himself and his personal capacity as a litigant, which means he should be subject to all of the same rules of discovery. He's no different than anybody now walking in the door. And so, if somebody brought something like this in front of a federal judge, you and I know in federal practice, I've seen a federal judge say, hey, show up in court, plaintiff, and I want to hear from you. Take the witness stand. To which Trump would always be like, I'm too busy, executive power. I can't.
We'll drop it. Yeah,
I can't do. I can't do any of that. And so, you're a litigant. And Harry, what really needs to happen in these cases where Donald Trump is the litigant, and he picks his cases against Rupert Murdoch and media networks where he knows. It's kind of like a Venezuela invasion deal where he kind of, has his Delcy Rodriguez there, and they say the things that make it look like they're against him, but they're kind of working together at the end of the day. And it's like even the case against the Wall Street Journal, any litigant in the Journal's position would immediately propound discovery on the guy and set a deposition. And, they don't do that because the handshake agreement is, we're going to file the motion to dismiss. You'll probably lose. You'll appeal it. You'll get your headlines, but we'll just have a little kind of detente. We'll tender it to our carrier and just go through the motions. Right. It's part of doing business with Donald Trump, but it's really an idiotic and dangerous and vexatious world by him.
The media lawsuit pattern is revealing. Trump files knowing the defendants won't fight aggressively because they want to preserve business relationships. But this case is different because it involves stealing taxpayer money under direct judicial scrutiny.
Main point I wanted to add, Ben, is it's the damn Constitution. If there's no standing, it's a collusive lawsuit. There is no jurisdiction. So your point is well taken, but the judge is going to be in a little bit of a tough spot herself, because if there's no jurisdiction, she can't stay the case. She can't do anything to the case. The case is just gone and non-existent, even if that means the statute runs and whatever. So the attempt to try to do rough justice here, it's the Constitution. It's not about rough justice. It's about yay or nay. On the other hand, to find that there's jurisdiction here when obviously they're in bed together, that would be, sort of Alice in Wonderland result. I don't see her doing it, but maybe it goes up. I think what's above them, the Fourth Circuit. Anyway, this is going to keep playing out, but it's this one way or another because it's the Constitution.
This case will set precedent for presidential corruption for generations. If Trump can steal $10 billion through fake lawsuits, future presidents will try even worse schemes. Constitutional integrity and judicial independence are literally on trial here. There you have it, everybody. Everybody hit subscribe here. Let's get to 7 million subscribers. But more importantly, subscribe to the Talking Feds YouTube channel. That's Harry Litman's channel. Help Harry get 1 million subscribers. And also you can subscribe to the Talking Feds podcast and the Talking Feds Substack. Thanks, Harry. Judge Williams and these amicus lawyers are the last line of defense against presidential theft. This isn't about politics. It's about whether courts will rubber stamp corruption or uphold the rule of law that makes America a democracy.